Welcome back, everyone. Nick Rekieta went live on YouTube, not so much Rumble, last night at midnight Eastern, 11 p.m. Central Time, and it wasn't the fun stream that I think he intended it to be. So shortly before he went live, some documents were released from the Court of Kandiyohi County, State of Minnesota, case type CHIPS, or Child in Need of Protective Services. And let me say, it brings me no joy to bring this news to you. It is believed to be a genuine document, although I did not get this from the district court website, so it is believed to be a leak. So, in the matter of the welfare of the children of Kayla Rekieta and Nicholas Rekieta, parents, and this is findings of fact, conclusions of law and order following a joint emergency protective care hearing and admit/deny hearing. The above entitled matter came before the undersigned judge of district court on June 6th, 2024. At the Kandiyohi County Courthouse, Wilmar, Minnesota. Present at the hearing were the following: Kristen Pierce, she is the Assistant Kandiyohi County Attorney, Prosecutor. Rachel Molesbury, same. Alicia Sweep, and she is with the Kandiyohi County Health and Human Services. It's going to be referred to going forward as KSHHS. Don Weber is attorney at law with and for Nicholas Rekieta. John Mueller, attorney at law with and for Kayla Rekieta. Also present were Carter Grainer, attorney at law with and for the children, and guardian ad litem. The foster parents also appeared. All parties and participants appeared in person. At the beginning of the Joint Emergency Protective Care hearing and admit-deny hearing, the court met the requirements for hearing procedure outlined in Minnesota, and it gives the statute. Minnesota, our Juvenile P procedure for 6.03 sub 1. Based upon the petition and attachments herein and on the testimony and exhibits, the court makes the following findings of fact. Subject matter, the children's subjects, and they are listed by name with middle initial and date of birth. I'm redacting all of these. There's no reason for them to be listed here on YouTube. Number 2, venue is proper in Kandiyohi County because the children reside in this county, so it's stating jurisdiction. Parentage, Kayla Rekieta is the mother of the minor children. Nicholas Rekieta is the father of the minor children. Ms. Rekieta and Mr. Rekieta are married, and they share joint legal and physical custody of the children. 4, petition. A CHIPS petition was filed on May 24th, 2024. The alleged statutory grounds listed in the CHIPS petition are incorporated herein by reference. Prima facie finding child protection matter. So prima facie means literally in Latin, on its face. So the bare bones has been provided that yes, there is absolutely cause to look into this. That on its face, yes, it does appear that there is a reason for child protection. There is a reason that child protection is needed. The court previously found that the petition establishes a prima facie or showing that a juvenile protection matter exists and the children are the subjects of that matter. So very little has to be proven for prima facie. This is just like, we've seen enough, we know enough that this can be done. Prima facie finding regarding endangerment. Also, that was also found. The court previously found that the petition establishes a prima facie showing that the children's health, safety, or welfare would be immediately endangered if the children were released to the care of the parents. 7. Service. Mr. Rekieta and Ms. Rekieta were each personally served with the summons and petition on May 28, 2024. Motions to intervene. No motions to intervene were made. 9, it states the protections of the Indian Child Welfare Act do not apply to this case. 10, McKenna's Law. So I looked this up. McKenna's Law is specific to Minnesota, and it is named after a minor named McKenna Ehrenholz. And this was effective as of 2017. And at the time, she was 12 years old, and she spoke up about being a foster child in Minnesota, and she didn't know that she had the right to her own attorney. And she also didn't receive an attorney after asking for one 3 times after spending time with her abusive father. So McKenna wanted to ensure that other children in her situation didn't have the same experience. So during the 2017 Minnesota legislative session, McKenna's Law was passed. So McKenna's Law states that when a 10-year or older child is removed from home and placed in foster care, the social worker shall inform the child of the child's right to be represented by a lawyer and of the child's right to personally attend court hearings. The law also provides that only the child can waive their rights to be represented by a lawyer, and only after an opportunity to talk to a lawyer first. That went into effect on August 1st, 2017. So McKenna's Law is referenced here. Number 10, the court provided the McKenna's Law advisory to the children, 3 of the minor children that would be over the age of 10 due to McKenna's Law. Representation. The parents were previously advised of the right to be represented by counsel on the record as required by Rule 36, and the parents were each represented by an attorney at the hearing. 12. Ex parte hold and order for hearing. The children were placed on a law enforcement hold. The date of removal is May 23, 2024. The facts that warranted removal of the children from the caregiver on an ex parte emergency basis, ex parte meaning one side, that the parents didn't agree to this. On May 23, 2024, law enforcement officers from the Kandiyohi County Sheriff's Office executed a search warrant at the family residence. We already know about that. During the search, narcotics and drug paraphernalia were located. The parents were placed under arrest, and the law enforcement officers placed the children on a law enforcement hold. 13. Continued EPC hearing. EPC is Emergency Protective Care. An EPC hearing was scheduled to be held on May 28, 2024. At that time, the parents motioned to continue the hearing for good cause. The court found good cause to continue the EPC hearing to protect the rights of the party. It doesn't state what they actually said was the reason. 14. Testimony. The court received testimony from Alicia Sweep, which we saw in the parties that were at the hearing to be from the Kandiyohi Health and Human Services. Christy Barber is the guardian ad litem, and Robert Rekietas. I believe that's his father. All witnesses were placed under oath prior to providing testimony. 15. Exhibits. The court received the following exhibits. A. Exhibit 001, drug testing of the parents. B. Exhibit 002, drug testing of the children. 16. Protective care determination. All parties and participants were offered the opportunity to cross-examine petitioner regarding the ex parte filings. After receiving additional facts, the court determined that protective care shall continue. The court makes the following explicit and individualized findings in support of continued placement. KSHHS received a report involving Mr. Rekietas and Ms. Rekietas on May 23, 2024. The report was that law enforcement was going to the home of Mr. Rekietas and Ms. Rekietas to execute a search warrant. B. Upon executing the search warrant, the law enforcement officers found over 26 grams of cocaine, ketamine, drug paraphernalia, firearms, and ammunition in the home. C. Ms. Sweep, who is with the Health and Human Services, went to the family home while the search was ongoing. At that time, she learned that the home was very cluttered. It was difficult to walk around the home without stepping on clothing, bedding, or blankets. And it lists the children, except for the oldest child, who were present at the home at the time. The oldest child was not there at the time. D. After being placed out of the house, the children were subject to hair follicle drug testing. All of the children except one tested negative. The child who tested positive on this date on the date of the testing, she was 8 years old. She has since turned 9 years old. She tested positive. Tested positive for cocaine at a level of over 5,000 with a cutoff of 500. Now, I did look into the possibility of a false negative because false negatives happen all the time. You know, if you take a particular medication, it may show up on a drug test as something illegal. And especially for children, if they're taking ADHD medication, this is what I was thinking. I looked into it. My source is Oxford Academic and the American Academy of Pain Medicine. Now, in the court filing, if this is authentic, it doesn't say what the unit of measure is for the 5,000 or 500. For a positive negative cutoff concentration is 150 ng per ml. So I don't know if that's the same unit of measure used in this test. So according to this source, a positive cocaine results are extremely rare, and if they do exist, it's usually from a urinalysis, a urine drug screen, and this was hair follicle. And also I took a look at the National Library of Medicine, the National Center for Biotechnology Information, which is a U.S. government website, PubMed Central, and it states that positive cocaine screens, however, are possible after drinking tea made from the leaves of the coca plant, having cocaine used as a part of a topical preparation, and we're talking about liquid cocaine, or using adulterated products. And there is a metabolite that from cocaine that can be detected in urine drug screens. So there's a high degree of specificity even in the urine drug screens. Prior research has found that false positive results in the cocaine urine drug screen are rare in the absence of other members of the cocaine family of chemicals. So basically that it's extremely improbable, according to these sources, that this would be a false positive test. And again, this was not a urine drug screen that the court performed. They did hair follicle analysis. So obviously we're talking about a minor here, and I am not a scientist, and I'm definitely not a lawyer, and I am just telling you what I found. It's very sensitive talking about a minor. This is a very serious situation for everyone involved, but I did want to just add that. Mr. Rekieta and Ms. Rekieta each submitted to a hair follicle drug test through Minnesota Monitoring Incorporated on May 30th, 2024. However, KSHHS has not received the results of those tests because subsequent to taking those tests, Mr. Rekieta and Ms. Rekieta revoked their release of information from the lab to Health and Human Services. Because the release of information has been revoked, HHS has been unable to monitor the parents through additional drug testing. So they submitted to the hair follicle drug test and said, don't release the information. Don't release the results. Ms. Sweep, again, who's from the county HHS, went to the home on May 28th, 2024. She was allowed into the home, but was not allowed access to the parents' bedroom. The guardian ad litem is in agreement that it is in the best interest of the children to remain out of home placement at this time. 17. Surroundings or conditions. The children are in surroundings or conditions that endanger the children's health, safety, or welfare, requiring responsibility for the children's care and custody to be immediately assumed by the county KSHHS. 18. Contrary to welfare and best interest, children out of home. It is in the best interests of the children for care, custody, and control of the children to remain with Kandiyohi County HHS for the purpose of placement with a suitable foster care provider. Continued custody of the children by the parents is contrary to the welfare of the children. The placement proposed by KSHHS is in the children's best interest. In making this finding, the court relies upon the best interest factors considered by KSHHS as set forth in the CHIPS petition, which are incorporated herein by reference. It is in the best interest of the children to remain in foster care until the parents are able to provide a safe environment demonstrated through substantial compliance with the case plan and by correcting the conditions which have led to out-of-home placement. The placement proposed by the agency is the least restrictive and most home-like setting that meets the needs of the children. Reasonable efforts. Given the particular circumstances of the children and family at the time of children's removals, there were no services or efforts available that could have allowed the children to safely remain in the house. 20. KSHHS is providing reasonable efforts to reunify the children with their parents and to prevent the need for further out-of-home placement. However, those efforts have been hampered by the parents because the parents have revoked the release of information for their drug test, have not been submitting to drug testing, and have not allowed KSHHS full access to the home. 21. Removal date and permanency deadlines. The children were removed from the home on May 23, 2024, which is 14 days in out-of-home placement. The permanency progress review hearing must be held no later than 180 days after removal, which is November 19, 2024. If applicable, the permanency petition must be filed no later than 335 days after removal, which would be April 23, 2025. If applicable, an admit-deny hearing to determine the permanent status of the children shall be held by May 23, 2025, pursuant to Minnesota Statute 260C.503, sub 1. 22. Admit-deny hearing was held on June 6, 2024. The parents were each represented by an attorney. The parents were advised of the right to have a trial regarding the CHIPS petition, including the right to testify or question and call witnesses at the trial, and to require petitioner to prove its CHIPS petition by clear and convincing evidence. After consulting with counsel, the parents each entered a denial. 23. Protective order. The parties have agreed to a protective order for discovery. Discovery is the evidence. 24. The parents have agreed to waive the timely requirement that the pretrial hearing be held at least 10 days prior to the start of the trial. Conclusions of law. 1. Best interests. It is in the best interests of the children that they shall remain in protective care of KSHHS for the purpose of placement with an appropriate licensed foster care provider. 2. Reasonable efforts. KSHHS is providing reasonable efforts to reunify the children with their parents and to prevent the need for further out-of-home placement. However, those efforts have been hampered by the parents because the parents have revoked their ROI, the release of information, and have not been submitting to drug testing and haven't allowed KSHHS full access to the home. It does mention again the Indian Child Welfare Act does not apply to this case. And here is the court order. The children shall remain in the protective care of KSHHS for the purpose of placement with an appropriate licensed foster care provider. Rekietas children are with a foster family. Services, examinations, or evaluations. The following shall be provided to the child and the child's family pursuant to Rule 42.09. The parents shall each submit to a chemical use assessment and shall follow all recommendations. The parents shall abstain from the use and possession of all mood-altering substances except as prescribed by a medical professional. The parents shall each submit to chemical testing of any type at the request of KSHHS and or the guardian ad litem to verify abstinence. The parents shall sign all necessary releases of information so that the service providers may share information with KSHHS and the guardian ad litem. The parents shall sign releases of information from the lab, the drug testing lab, to KSHHS and the guardian ad litem so that KSHHS and the guardian ad litem may monitor and verify the parents' drug testing results. Out-of-home placement plan. KSHHS shall file an out-of-home placement plan and provide it to the parties and foster care providers within 30 days of the court order, placing the children in foster care, an order for protective care, or order transferring legal custody to KSHHS, whichever is earliest. The out-of-home placement plan shall be filed no later than June 22nd, 2024. Family time. The terms of parental and sibling visitation pending further proceedings are: visitation between the parents and the children shall be supervised at a supervised safety center or supervised at the KSHHS building by a member of KSHHS staff. Relative search. KSHHS shall exercise due diligence to identify and notify adult relatives of the family within 30 days after removal, pursuant to Minnesota Statute 260C.221. The agency shall continue to appropriately involve relatives who have responded to the notice. The parents shall cooperate in providing sufficient information to identify relatives. No later than 90 days after placement, the agency shall report to the court its efforts and decisions regarding placement according to Minnesota Statute 260C.221 D1 and 2. This order shall be shared with providers of service under the case plan, and such providers are authorized to share information with each other as necessary to carry out the intent and purpose of the case plan ordered herein. And it goes on to say that the county is authorized with respect to the children to arrange for major medical care and surgery if the children need it or if they're in a life-threatening situation, to arrange appropriate routine medical and dental care, including necessary immunizations and vaccinations for the children, to obtain the children's educational, medical, dental, psychological, psychiatric, and dental records, including mental health and chemical dependency records, if any, for the purpose of meeting the children's health needs, and to approve educational or mental health services for the children as needed. And it says this is because this is the court order. It states specifically what they're authorized to have access to, and medical data, corrections and detention data, juvenile court data, court services data, health records data. Providers of services to the children, including education, medical, and mental health, are authorized to release information regarding the children to the county. This order shall be shared with providers of service under the case plan, and such providers are authorized to share information with each other to carry out the intent and purpose of the case plan ordered herein. So there is a deadline for discovery of July 15th, 2024. Pursuant to Rule 6 of the Rules of Juvenile Protection Procedure, this order establishes the following deadlines or specific dates for the proceedings in this matter. Deadline is July 15th. This includes the following: inspection and copying of documents or other tangible evidence, identify the names and addresses of all persons intended to be called as witnesses at the trial, and shall allow all other parties to inspect and copy witnesses' written or recorded statements within the parties' knowledge relating to the case. Identify the names and addresses of all persons intended to be called as expert witnesses at trial, the subject matter about which each expert is expected to testify, and a summary of the grounds for each opinion to be offered. The following additional pretrial preparation and discovery is authorized, and the reports from such discovery shall be completed and disclosed to the other parties: physical examination, psychological examination, depositions. All proposed exhibits must be uploaded to the Minnesota Digital Exhibit System no later than July 15th. That is the deadline for discovery. All pretrial motions shall be filed and served by July 15th. Pretrial conference shall be held on July 15th at 3 o'clock Central Time. The parties and their legal counsel shall come to the pretrial conference prepared to determine whether a settlement of any or all issues has occurred or is possible, and to discuss the issues set forth in Juvenile Protection Rule 48.02. Trial. Trial in this matter shall begin on July 23rd, 2024, the 24th, the 25th, or the 26th. At 8:30 a.m. Central Time. The parties shall be ready to commence trial on any of the given dates. The court will try to notify the parties of the priority status 1 week prior to trial. The trial shall not be continued or adjourned for more than 1 week, unless the court finds that continuance or adjournment is in the best interest of the children. The trial shall continue until completed. The trial shall be conducted pursuant to the procedure set forth in Rule 49.02. Court settlement conference. The parties shall participate in a court settlement conference or other form of alternative dispute resolution. All hearings will take place at the Kandiyohi County Courthouse, Wilmar, Minnesota. This order is subject to revision as necessary to serve the best interests of the children and the interests of justice, so long as the permanency timelines are not delayed. All previous orders of the court remain in effect, except as explicitly amended herein. And this is signed by Keith Hegelson, Judge of District Court, June 7th, 2024, 2:26 p.m. Central Time. In Nick Rekietas' stream last night, he did reference this filing. Of course, he says he can't talk about it. You'll see clips of that. I'll put some clips on my channel as well. It doesn't seem like a good situation from here. If I do get any more clarification on that filing, if there's other news about that filing, I will certainly bring it to you. Thanks for watching.